We're going to call to order the special meeting. Let's go. Of the Pontiac Charter Revision Commission for March 20th, 2024. Roll call.
Commissioner Burrows. Payne. Ramsey.
Present.
Here.
Stewart. Turpin. Williams.
Present.
Ibarra.
Present.
Madam Chair, you have a quorum.
Yay. Authorization to excuse Commissioners Burrows, Stewart, Payne, and Turpin.
Moved.
Support.
It's been moved by Williams and supported by Ibarra. Roll call.
Commissioner Garrett.
Yes.
Killian.
Yes.
Ramsey.
Yes.
Williams.
Yes.
Ibarra.
Yes.
5 yeas.
All right. Amendments to any amendments to the current agenda? Approval of the agenda as is.
I move.
Support.
It's been moved by Williams and supported by Ibarra to approve the agenda as is. Roll call.
Commissioner Killian.
Yes.
Ramsey.
Yes.
Williams.
Yes.
Yes.
Garrett.
Yes.
5 yeas.
Approval of minutes for February 22nd, 2024. Is there a motion?
Moved.
Support.
Moved by Williams, supported by Ibarra. Roll call.
Commissioner Ramsey.
Yes.
Williams.
Yes.
Ibarra.
Yes.
Yes.
Killian.
Yes.
5 yeas.
Public comment?
None.
Thank you. All right, I believe we have, we need to review the correspondence from the governor's office and the attorney general's office, and we have a representative from the law firm to help us go over this. That's correct? That's correct. All right.
Thank you, Madam Chair, Vice Chair, members of the Commission. I have had an opportunity since the last Charter Commission where the draft 2024 Charter was approved by this body. It was forwarded to the Attorney General and to the Attorney General's office consistent with the direction of the Commission. I've had several conference calls with the Office of the Attorney General's assistant in charge of charter review and charter proposals. And there's a series of, I would suggest, minor edits that he wished to bring to the Commission's attention. A couple of them are a little bit more substantive, which I think need some deliberation by the Commission on. I have provided to you a marked up version of the proposed charter, which incorporates, hopefully yours is colored, where the highlighted changes and edits are in red. I don't know if that came through for you. It would have made it a lot easier for you to see them. But if it pleases the chair, I'll just go right through those in order. One of the initial comments that the Assistant Attorney General suggested was to include a table of contents. The table of contents you already had, but it was not provided in the draft that was approved by the Commission at its last meeting. I've incorporated that into the version that is before you, and hopefully the Commission views that as an appropriate modification. Going into some of the other...
Oh, if you could hold for one moment. Commissioner Williams, can you say that for the record, please?
Yeah, do
I did not.
it. So, just for the record, I was asking the chair if it would be better to approve the changes as we go, so that way we can just vote on the entirety at the end. If that makes sense. Like, for example, if we agree with adding the table of the table of contents, then actually saying, taking a roll call vote so we can approve it.
I'm going to defer to the commission on that. It may help the clerk with respect to recording the process rather than a long, cumbersome motion at the end. I think it probably does make the most sense. Good evening.
Yes, I think we should do that, just so we don't get anything confused. There might be some issues that we have to hold off on. So if we could, after you give each proposed change, then we will vote on it as a commission. So the first one would be, is there a motion to approve the table of contents as provided by the law office? Is it the law office of Doug Christ?
It's Hafley, Steeren, and Christ.
Okay,
My name, again, Madam Chair, is Dan Christ.
Dan Chris, okay. So can I say as provided by the law firm? Okay. So,
Okay, I make a motion to approve the table of contents as provided.
Support by Garrett.
moved by Williams and supported by Garrett. Roll call. Oh, discussion. Discussion. Okay, roll call.
Commissioner Ramsey,
Yes.
Williams,
Yes.
Ibarra,
Yes.
Burrows, Garrett, Killian. 6 yeas.
If I could continue, I'm going to skip over the first change, which is in 2.102, because I think that's going to take a little bit more explanation, and go to the next proposed change, which is section 2.112. It's the oath of office. The oath of office proposed in the previously approved draft did not mirror the language of the Michigan Constitution in 1963. The Attorney General, the Assistant Attorney General, wishes for the language to be exactly as set forth in the Constitution of 1963. So that is what is provided in the draft before you. I can read it into the record if you want, or it's in your text.
If you could read it into the record, please.
The proposed edit would read, I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of this state, and that I will faithfully discharge the duties of the office of blank according to the best of my ability.
Thank you. Is there a motion to approve the language as read?
Support by Garrett.
It's been moved by Williams and supported by Garrett to approve 2.112, oath of office as read. Discussion?
Oh, okay.
Roll call?
Commissioner Williams,
Yes.
Ibarra,
Yes.
Burrows, Garrett, Killian, Ramsey.
Yes.
6 yeas.
Continuing the next proposed change, 3.112, which identifies ordinance procedure, subpart B, the Attorney General believed that there was language missing in the draft. In discussing the matter, it seemed that it should be, in what is proposed before you, language that would indicate shall publish a copy of the ordinance or a summary of the ordinance determined by the clerk. Previously, it didn't identify what was to be published.
It's been moved and supported. Can you one more time explain what the change was?
Yes, in the third line, the section 3.112 sub B indicated that the clerk, after introduction, would publish something, but it didn't identify what was to be published. So
Okay.
the proposed text is that either a copy of the ordinance or a summary of the ordinance to be determined by the clerk would be published.
You got that? Okay, thank you. It's been moved by Williams and supported by Burrows. Discussion? Roll call?
Commissioner Williams,
Yes.
Ibarra,
Yes.
Burrows, Garrett,
Yes.
Killian,
Yes.
Ramsey.
Yes.
6 yeas.
Continuing in 3.112, if you go to subpart F, there was a concern from the Assistant Attorney General that it only would be posted at City Hall. He suggested that this is again addressing emergency ordinances, that it be also published or that it also be posted at other locations. And after conferring with him, he agreed that 3 other public places in the city would be an adequate type of proposal. So the proposed text that's been added to the previously adopted version would say, at City Hall, and then the new text, and 3 other public places in the city, as determined by the clerk, who shall maintain a record of the locations of postings.
I move.
It's been moved by Williams and supported by Burrows. Discussion? Roll call?
Commissioner Williams,
Yes.
Ibarra,
Yes.
Burrows,
Yes.
Garrett, Killian,
Yes.
Ramsey.
Yes.
6 yeas.
Continuing on, still in 3.112, if you move forward to subpart J and K, there were 2 minor spelling issues. In J, second line, there should be the word A before section. And then in K, on the last line of that paragraph, after the word condition, it should be S. It should be conditions.
I move it.
It's been moved by Williams and supported by Burrows. Discussion? Roll call?
Commissioner Ibarra,
Yes. Yes.
Garrett,
Yes.
Killian,
Yes.
Ramsey,
Yes.
Williams.
Yes.
6 yeas.
Madam Chair, next section, 3.113, in the third line down, the first 3 sentences is dealing with real property. The 4th sentence appears to be dealing, it previously said other property, and talking that through, it seemed that the word personal property was missing from that sentence. And then the Attorney General wasn't sure what as a minor meant in the next line. He proposed, and after conferring with him, I agree that it makes it more readable for that sentence to read, the city may not sell any personal property that may have been defined by ordinances. Delete the word as a minor, and then continuing the sentence without approval by resolution of the council.
I move it.
Oh, hold on 1 second. It's been moved by Williams and supported by who? Garrett. All right, discussion. Burrows.
So we're saying the city can't sell real property or personal property?
Without the approval of council.
Any other discussion? Roll call?
Commissioner Burrows, Garrett,
Yes.
Ramsey,
Yes.
Williams,
Yes.
Ibarra.
Yes.
The next section, at the top of the next page, page 9, 3.116, investigative powers. It appeared that there was a repetitive reference to appropriate boards or commissions. The last line, the third from last line says the council shall apply to the appropriate court and/or appropriate board or commission, suggests deleting the word "and," empowered with investigative powers, and then delete the additional references to the appropriate board or commission.
I move it.
Support?
It's been moved by Williams and supported by Ibarra. Excuse me. Discussion? Roll call?
Commissioner Garrett,
Yes.
Killian,
Yes.
Williams, Ibarra,
Yes.
Burrows.
Yes.
6 yeas.
Moving to section 4.101, in subpart A regarding eligibility for the office of the mayor, the Attorney General Assistant was concerned with the references to the requirement that such an individual have a primary residence in the city for 2 years. And he indicated there's an Attorney General opinion suggesting that that's too long and maybe not permitted. He suggested, because there is court decisions that allow for a 1-year residency, have affirmed that length of period of time. So the proposed change that he's asked the commission to consider would be to change that to 1 year.
It's been moved by Williams and supported by Garrett. Discussion? Turn your mic on. Go right ahead.
Yes, you said we have case law that says the 2 years is too long?
Yes, that's, well, he referenced it as an Attorney General opinion, but there is case law that says 1 year is permitted.
So if the 1 year is permitted and we're asking for 2, we understand the 1 permitted because it's already in there, and I'm trying to get some clarification because this was one of my stickler points of increasing it, and I'm trying to see why it can't be increased. Is there a case law that says 2 is too long, or that's just his
Well,
opinion?
he indicated there's an Attorney General opinion on that subject. And he's going to review it. I don't know if he's going to flag the charter based on that. He asked that the commission consider that issue to 1. He and I both talked, and I knew and know of the case that allows for 1 year. I'm not aware of any binding case law that says 2 years is prohibited, but he is relying on his office's opinions.
Thank you.
Yeah.
Discussion?
Discussion.
Yeah, I know, I understand what you're saying, and I think 2 years would be appropriate, but I also realize that we're against the 8 ball, and if it's gonna stop the rest of the charter, I don't think this is the most important thing for it not to get passed, so. No, I just don't think it's the most important thing. It's not to me. It's what I'm saying is, out of these 50 pages, I don't think this is the most important thing in the charter.
So this is also a sticking point for me, but I also want to get it passed, but I don't like it. Garrett?
And I agree, but just having to work in this, anybody goes to a deciding factor through policy, they go to their Attorney General opinion. And so I haven't yet to see a case law be developed of making a mandated of 2 years. And it's not something like we can't explore it afterward. So I was okay with, when I saw it, like, you will be asking this same Attorney General their opinion, and they're going to give you the 1-year opinion. So I just, okay. That was it.
Discussion?
But just upon advising, though, when we did put in renewal of the charter, that's when you can start having more of a deeper conversation and having the Attorney General put an opinion together based upon it, that you may add it in the when you go back to look at the charter again. So it's not out. So that's, it's just timing at this point.
Go ahead, Killian.
So with it being his opinion, and we're saying it's flagged, if it's flagged, that means we hold up the whole process of it passing.
Through the chair, potentially.
Potentially.
He requires approval of his office, and the governor is looking to the Attorney General's recommendation and approval of the language of the charter as well. So there's some level of risk on that. I can't quantify it, but he has expressed concern with it. So that's why I've presented it to you.
All right. Thank you.
All right, any further discussion? Roll call. So we have adopted moving it back to 1 year. So that's what this will do. All right, roll call.
Commissioner Killian,
No.
Ramsey,
Yes.
Stewart,
Yes.
Williams,
Yes.
Ibarra,
Yes.
Burrows. No. Garrett.
Yes.
5 yeas, 2 nays.
All right, so it went through.
The next section would be in 4.202, subpart H. Towards the end of that sentence, there was language that didn't read correctly in the mind of the Assistant Attorney General. I'm sorry, I got a terrible sore throat. But it's page 15, subpart H. It currently, as approved by the commission, read, representing any elective officer or appointee of the city in any action or proceeding involving official duties. It seems repetitive. And so the proposal was to delete the reference, any action or proceeding involving, so that it only has that reference once.
I move to adopt.
It's been moved by Stewart and supported by Williams. Discussion? Roll call?
Commissioner Ramsey,
Yes.
Stewart.
Yes.
Williams,
Yes. Yes.
Burrows. Garrett. Killian.
Yes.
7 yeas.
Next section, 4.403, powers and duties of police chief. This is just really another redundancy. The third line down, where it currently reads, and ordinances of the city, it then repeats by ordinance, which is not necessary. So the proposal would be that it just read, and the enforcement of criminal laws of Michigan and ordinances of the city, period.
I move to adopt.
It's been moved by Stewart and supported by Williams. Discussion? Roll call?
Commissioner Ramsey,
Yes.
Stewart.
Yes.
Williams. Ibarra,
Yes.
Yes.
7 yeas.
The next, the next item, 5.102, there appeared to be a missing word after the reference to at least 75. It should be after 75 days.
I move to,
5.102 on page 19.
What was the catch?
The word days was not in it.
Oh, okay.
I move to adopt.
Support.
It's been moved by Stewart and supported by Ibarra. Discussion. Roll call.
Commissioner Stewart.
Yes.
Williams.
Yes.
Ibarra.
Yes.
Killian. Ramsey.
Yes.
7 yeas.
This next section would be 5.106. There was a reference to interim authority where there had been, council might have had, for some reason, not made an appropriation. The Attorney General does not think there's authority there for essentially where there's not been an appropriation to still fund some aspect of the city's government. And so he suggests that the section be deleted.
Support.
It's been moved by Williams and supported by Stewart. Discussion. Roll call.
Commissioner Williams.
Yes.
Ibarra.
Yes.
Burrows. Garrett.
Yes.
Killian.
Yes.
Ramsey.
Yes.
Stewart.
Yes.
7 yeas.
At the top of the next page, page 20, 5.10, what is now being renumbered since 5.106 was deleted, this would now be renumbered to 5.106. And then additionally, on the third line, there's an extra word, is, halfway through the line, which should be deleted.
I move to adopt.
It was 5.107. 5.106 is now deleted.
So Stewart has motioned. Is there support?
Support.
It's been moved by Stewart and supported by Williams. Discussion. We had it already, though. Roll call. 5.106 is the new 6. It was 7.
Commissioner Williams. Ibarra.
Yes.
Burrows. Garrett. Killian.
Yes.
Ramsey.
Yes.
Stewart.
Yes.
7 yeas.
Next item at 5.301 and 5.302, there's just two minor spelling issues. At the second from last line of 5.301, there should be a period after year, fiscal year. And then 5.302 on the fourth line down, after unless the finance director fined, should be fines with an S.
Oh, y'all
Support.
good. Y'all good. Y'all good.
It's been moved by Williams and supported by Stewart. Discussion. Y'all firm did an amazing job. All right. Roll call.
Commissioner Ibarra.
Yes.
Burrows. Garrett. Killian. Ramsey.
Yes.
Stewart.
Yes.
Williams.
Yes.
7 yeas. I'm running out of shit.
5.409 on the first line, it's publication. It reads currently as approved, the city treasurer shall give notice in a by means. The word in a should be deleted. It should read, the city treasurer shall give notice by means established by ordinance.
So moved.
5.409.
It's been moved by Stewart and supported by Williams. Discussion. Roll call.
Commissioner Burrows? Garrett?
Yes.
Killian?
Yes.
Ramsey?
Yes.
Stewart?
Yes.
Williams?
Yes.
Ibarra?
Yes.
7 yeas.
The next section, 5.411, second line, the word as should be the word all. So it should read, assessor shall spread upon the assessment roll all school and county taxes.
Support.
It's been moved by Williams and supported by Stewart. Discussion. He got here late, but he on the road now, strolling in with them chips. Okay.
We can keep going for a minute.
Roll call.
Commissioner Garrett?
Yes.
Killian?
Yes.
Ramsey?
Yes.
Stewart?
Yes. Yes, sorry.
Williams?
Yes.
Ibarra?
Yes.
Burrows? 7 yeas.
Continuing the next section, 5.416, the first sentence appears to largely be duplicative in the second sentence. So the suggestion was that there only be one reference to the assessment, levy, collection, and return of taxes shall be governed consistent with this charter and law. And so the first sentence, which says general law shall govern the assessing, levying, collection, and return of taxes except as otherwise provided by this charter, is recommended to be deleted.
Okay, is there a motion?
Motion.
Okay, is there support?
Support by Garrett.
All right, it's been moved by Stewart, supported by Garrett. Any discussion?
Discussion.
Go ahead.
Do you know why they chose the first sentence over the second?
No, and frankly, I think it could go either way. I don't think it,
Because I was just reading it, and I was just wondering. Okay, consistent.
both of them reference consistent with the charter and law.
Yeah. Okay, thank you.
Any more discussion? Roll call, Madam Chair. Madam Clerk.
Commissioner Killian?
Yes.
Ramsey?
Yes.
Yes.
Williams?
Yes.
Ibarra?
Yes.
Burrows? Garrett?
Yes.
7 yeas.
The next section, 6.101, the suggestion was just to modify the title of that section consistent with what it's representing now, to non-discrimination as opposed to the previous text of affirmative action.
So moved.
Support.
Okay, I'm sorry, I totally missed that. Did we get a motion?
Yeah.
Stewart, and who second? And Ibarra. All right, it's been moved by Stewart and supported by Ibarra. Discussion? Roll call.
Commissioner Ramsey?
Yes.
Stewart?
Yes.
Williams?
Yes.
Ibarra?
Yes.
Burrows? Garrett?
Yes.
Killian?
Yes.
7 yeas.
The next section, 6.106, that's the section regarding conflict of interest. The Attorney General was okay with the initial portion of it, but he thought sub 2 and B and C should really be referenced in a separate ordinance rather than in the charter. And so he proposes that it be deleted, but that I know obviously this commission spent a lot of time on that section, so I'm just
Okay.
the messenger on that.
Okay. Is there a motion? Well, don't we have to do that to have a discussion?
Well, not necessarily. I mean, because you said we vote on each one.
Oh, yeah, so yeah.
Yeah.
Okay, but somebody wants to make that motion, I don't make motions that I'm voting against.
I'll motion.
Okay, so we have a motion by Stewart. Is there a second?
It's moved by Stewart.
Second by Garrett.
Okay.
Okay, discussion. Go, Kermit.
Yeah, so I hear what the Attorney General is saying, but I think that because one of our mandates in creating this charter was coming up with some transparency and some other things, I think that we should keep this section in. I am open to modifying whatever language is not consistent in the section with what it needs to be, but I think that this is something that needs to be in the charter and give the citizens some kind of voice when it comes to conflict of interest in the city of Pontiac.
Thank you. I do have a question. Do you know why they were against this?
Well, he indicated first of all, with respect to the penalty section at the very end, he indicated normally there's not a penalty that's in the charter. And there's not authority for that. Usually your penalties are in ordinances. And so he was troubled by that aspect of the language and thought that it would be more appropriate because it could be tailored and potentially modified over time, that it would be a better subject for ordinance. But you could provide the part that he talked about and his concern reference to the penalties could be pulled out, and you could say that part shall be done by ordinance. That would at least address the expressed concern that he had regarding the penalty.
Okay, thank you. That's helpful. So 2 and 3, I really, and I know that you're a representative, just trying to understand the logic behind just getting rid of those altogether. I understand the penalties and taking those things out, but just in general.
Well, all I can communicate is what he said. If you want to put it back in, you can. I mean, he felt it would be better, but he's not the commissioner.
Yes.
All right, so the aspect with respect to the legal issue on the penalty, I think, is a legitimate one that you should consider carefully and maybe pull that aspect out. He was, I mean, as it relates to sub 2, he was concerned that it made the reference to 1% of stock, doesn't make it, which would normally be a corporation. He's like, well, what about a limited liability company? What about a partnership? Those references weren't, or other types of legal entities other than a corporation, which would have stock. There's other legal entities that don't have stock. They have members or membership. So maybe it needs to be broadened to include those types of references. And so that was part of his, he pushed back on that aspect.
Thank you.
And then segued into thinking that it shouldn't be there at all, so.
Thank you.
I was just gonna say, yeah, I think there's areas in here where I definitely think we could take out. I'd be fine to modify and change some of that. I do think we probably should keep it, and I think the reason for that, right, is that we've had a lot of these conflicts come up that it shouldn't, that the council also has had their own issues, and so having it just in council ordinance, I think, wouldn't necessarily be good or wouldn't necessarily get to the core of why we have it in here, which is to make sure that it's mandated in many ways. Because right now they do nothing. They don't even think they have their own conflict of interest. So there's those pieces. I think the things that I would want to make sure we keep in, while the 1% interest in the stock piece was there, so was also any contract with the city and the sale of land. It was broader in that piece, and I feel comfortable on those ends. And then in the B, I think B and C for me, I think B, if we took out the penalty, most of what that says is that these people shouldn't be engaged in hiring decisions, all of those pieces. That one is definitely critical. Pontiac is a small city, let me tell you that. Everybody knows each other. And then noting that they shouldn't have any holding any appointed position, I feel like those are relatively standard conflict of interest provisions as long as we take out the penalties. So I would definitely like to probably keep what we can.
Well, I mean, if I hear
Yeah.
some of the consensus, it sounds like from the commission, you could put two back in and put B back in. And the last sentence of B, you could modify to penalties for violating this section shall be, or council shall adopt an ordinance prescribing penalties for violation of this charter.
I'm sorry, say that again.
No, I said I can live with that.
Okay.
As far as taking out the penalties, but keeping it. We definitely need to keep those languages in there.
Thank you. Killian?
Yeah, I'm looking at, the proposal was to strike this totally, correct? Because of,
2 and 3
no, they have,
and B.
they also have a line through the actual one.
Oh, they wanted to,
Well, that's only because if two and, if
3
two
went
is,
away.
then it would
Three
not
went
have a
away, all of
numbering.
them had with it, and that's, was part of my question. And that you have, because I'm with the rest, that we can pull some of it out, because this is one of our other stickler points that I'm not gonna stand down on, but you have underlined, who shall provide the mayor, city council, and office of public integrity with a summary of the stated conflict. Is that underlined?
That, he actually talked about that, because the way it reads currently, an elective officer, appointee, or employee who has a conflict between personnel interest and the public interest as defined by law, this charter, or ordinance, shall disclose fully to the city attorney the nature of the conflict. It doesn't say what the city attorney is supposed to do with that information. And so the attorney general is like, what's the city attorney supposed to do now? Is he supposed to file it? Is he supposed to tell somebody? He thought that it should be communicated to the parties that are identified, the mayor, city council, and the Office of Public Integrity, with a summary of the stated conflict. That would complete the communication with respect to that type of disclosure.
Okay, in the second line, that was another added.
Well, then the last sentence of 1 only really fits if you're going to get rid of what I hear you saying you don't want to get rid of, which is 2 and B and C. So if those stay, then the last sentence of what was formerly 1 would come out.
All right. So, just for clarification, because we're going to need to rescind the motions, is that we are going to keep 1, removing the last line, the city council shall adopt an ordinance providing for penalties for violations of this section. So removing that. We are keeping 2, but we're removing the 1% financial interest.
I'm okay to keep that in, I think, and we, yeah.
We're keeping 2.
Financial interest, and I was gonna ask that, when you mentioned about LLCs and everything else, that would include an LLC, because it's saying financial interest, period, of any entity, or do we need to add of any entity?
Well, you could add that. I mean, he seemed to focus then on the second 1%, which you referenced, which talks about
Which was
stock
the common
in a
stock.
corporation.
So the 1%.
I mean, his point was you could talk about other types of legal entities. But you're right, Commissioner, you do already reference 1% financial interest, direct or indirect, in the
Right.
previous sentence,
Right.
which kind of begs the question of whether you need this second one that talks about the 1% stock.
Yeah. I wonder if we could, in a motion, approve like a broad statement to note that the attorney can make the changes that we identify, and we can note that that's just already approved for modifications. Is that something we can do?
He's saying we make a motion to say that our attorney knows what our interests are and what we're trying to say, and we'll change the language to reflect that without us wordsmithing it up here.
Well, I think you're doing a very good job. I'm making notes as you go, and Pat, I think it's better, although you,
Just for this,
I don't
yeah,
mind with very minor grammatical and spelling cleanup words, and actually my proposed resolution authorizes those types of cleanups to occur. I mean, I think this substantive provision, I think I'd prefer you to tell me how you want it to read.
I think we can do, I just don't want to have to come and bring this section back after it's rewrote.
Well-
That's what I'm, it's so that we can get the charter approved again.
Okay, so it sounds like we finna rewrite this right now. That's what it sounds like. Okay. All right. So we're gonna say any,
Hold on, before we start that, can you have the motion rescinded? So
oh,
I rescind my motion.
Garrett, I need you to rescind your second.
I rescind.
Somebody gonna need to call the authorities. Okay. So the motion and the second has been rescinded. All right, I'm trying not to smoke. So, we've already talked about section 1. We're keeping everything except the last sentence. Section 2, any elective officer, appointee, or employee who has direct or indirect or by reason of ownership any interest.
May I attempt to craft it
Please.
for you?
Please.
Two, as I understood the discussion, a possibility could read, any elective officer, comma, appointee or employee who has a 1% financial interest, comma, direct or indirect, in any contract with the city or in the sale of any land, material, supplies, or services to the city or to a contractor supplying the city shall make known that interest and refrain from voting upon or otherwise participating as an elective officer, appointee, or employee in the making or performance of the contract or sale, period. So really, the only text that would be coming out would be the, or by reason of ownership of 1% amount of stock in any corporation, and that's largely because it's redundant.
All right, so, hold on. 3, do we want to keep 3B and C as is?
You can't keep 3 because it notes that we're gonna have a penalty.
B does. Well, I was curious on 3, it talks about the rendering the contract or sale avoidable. Did he have a issue with it being, with that provision?
Well, I think that if legally, there's going to be an issue of after performance of a contract, the legality of the city trying to make it void, I think brings up legal challenges. And I think that's, the Attorney General hinted at that, but he didn't spend too much time on that, other than preferring that it not be there. So if you want to back in, you know,
I mean, I think it makes sense if it's, yeah. Oh, Killian has his hand up.
Killian.
So is it the point of having a penalty and an amount, that's the problem? Because 3 just is really saying the violation, and that's why I was referenced to be out, because it noted that. But if it's just about the amount of a violation, then I think that should be included. But I'm not, clear as far as what he's really looking for.
well, the part that's B, he was concerned mostly with that last sentence.
With the last sentence.
Yeah.
Okay. So if we just took out the last sentence, we still could keep 3. Will we have an answer of violation of this subsection? Contends upon what? Down here in 3, we're taking out what would answer that violation. So do we need to remove both? Is my question.
Or could we just remove further, a city officer or appointee violating this provision is guilty of a misdemeanor subject to fine? Take that out?
That's what I'm proposing. That's what he's concerned about. That
Yeah.
last part where it says further a city.
Yeah, it's the last sentence on B. Look at me. I'm getting it together. Hour 12.
So am I hearing it correct that currently under discussion would be to put 3 back in and B back in, except for that last sentence
Yes,
of B?
yes.
Though I wanted to note your concerns around 3 potentially not being illegal.
Well, I have that
Standard.
concern.
Yeah.
I mean, because there could be, when we're talking about 1% interest, direct or indirect, there could be, it doesn't even give a time frame. There could be largely or mostly performance of that contract, and then somebody says it's void. I think that legally
Yeah.
is going to be suspect, but
And that's 3?
That's 3, yeah. The violation of the subsection with the knowledge express or implied of the person or corporation contracting with or making a sale to the city shall render the contract or sale voidable by the mayor or council. I do think that is hard to
That's
manage.
what I was asking you
Yes.
to clarify. Because you have that in, it states that something has to be done.
Yeah,
So this is what I'm saying. Being that it states that, is that legally bound, like you say, with no time limits and no amount?
yeah.
well.
So I'm kind of,
It's in there right now. I think it would be tough to enforce at some point. I'm not in a position to say when or where the line is.
without a timeline or something being put in. Okay.
Okay, so the motion for 6.106 would be to remove the last line of section 1, would be to remove or by reason of ownership of a 1% amount of stock in any corporation on section 2, and to remove section 3, B is in boy and C is in cat in its entirety.
I don't think we need the entirety of B.
I just
more or
thought
less we just need that last
that
sentence
further
out there.
a city officer appointment violation.
But if we don't have 3, we're,
No, there,
So I think that we can strike 3 and then
Yes.
remove that further penalty sentence and then put in the sentence that Mr. Chris talked about with the city council creating an ordinance for the penalty.
correct.
so would that be the new 3?
No,
That would be the new B.
B.
the last, a new sentence at the end of B, which would say, if I can remember it, council
The
shall
city-
prescribe a penalty for violation of this section by ordinance.
Yeah, the city
Yes.
council, yep.
I guess I'm just looking at where B, it would be 2B then?
The reason is that it's different than just, it's its own provisions. B is its own provision.
Right.
So what it's noting,
Okay,
right?
okay, so B is its
yeah.
own provision.
And so what it's noting in B, right, is that, and it's because we're just not real at the
No,
cross that,
I
I think
get
is,
that. I just
but
wanted
it's
to-
that any relative should not be engaged in any hiring decisions, yada, yada, yada. So that's like, so that is a separate provision in and of itself.
That's
Yep,
where I was confused,
yep.
because I thought 3 was 3B, but 3 is a provision of its own.
Correct,
Okay,
yep.
that's where I was confused. All right, so we're gonna remove 3 and
Yes.
keep B, removing the last sentence.
Yes. And then,
What about C?
And just before we finish the B1 is to add the sentence, the city council shall adopt an ordinance providing for penalties for violation of this section
In the beginning, where you putting
at
that
the end,
Okay.
instead of the further.
And then I think we have to remove C because C is a penalty.
Yes.
I think that makes sense.
Okay. Okay. All right, we gonna get this. I don't know how. If I start getting too tired, I'm gonna go home. All right, so we're removing 3. We're removing C. We're removing the last line of B and adding what Commissioner Stewart read. So that's,
Can you say that again?
Yes, it is. The sentence would read, I just stole it from one, but it was, the city council shall adopt an ordinance providing for penalties for violation of this section. And I can read that just one more time because I talk fast. The city council shall adopt an ordinance providing for penalties for violation of this section.
It's
And I
been
have
moved.
these in notes too, so.
Okay. It's been moved by Williams,
Support.
supported by Killian. Discussion. Roll call.
Commissioner Stewart,
Yes.
Williams,
Yes.
Ibarra,
Yes.
Burrows, Garrett,
Yes.
Killian,
Yes.
Ramsey.
Yes.
7 yeas.
The next section, 6.107, the Attorney General was not sure what the purpose of that section was and struggled with what it really meant and what it was saying. He also didn't like the way it made reference to that section having ordinance status in the last line. He didn't really know what that was.
Yeah, I think my assumption on this is that it was, I believe, in looking back, I think this was something that the 2012 charter folks brought in. And this, I think, was relaying back to like all the retirement benefits for our retirees that are truly still an ongoing issue, to be honest. But I think that was the intention, but I think it's changed so much since 2012. I'm not sure how to update it enough, to fix it. That's what I'm worried about. I don't know, Kermit or anyone else, do you have a?
Yeah, I agree with you. I think that was part of the 2012 charter because we were going through all that pension debate, and they're still going through the healthcare debate now through that. So I don't know how to take it out. I do know that it probably should not say ordinance status. So I don't know how to fix that, but I don't know if we should take it out, but I think we should adjust it. So I don't know.
But if we don't know how to adjust it,
Well, I'm saying ordinance status is probably something that is not consistent anywhere else in the charter. That phrase is only in this section, is what I'm saying to you.
no, I'm saying, but the rest of it, like
Right.
what is,
What I'm saying is I wouldn't touch the rest of it. What I'm saying is I think that the ordinance status part is probably the problem that the Attorney General has.
no, the other part is he doesn't understand the purpose of this section.
Well, he doesn't, but, we can, the text is as you propose it, but he most specifically said, I don't know what it means, and I don't know what ordinance status means.
Go right ahead.
If I may take a stab at it. I'm in full agreement about taking that ordinance piece out because it's, again,
Ordinance status?
the ordinance status, because it's telling them what they, it's almost like you must do it, like but this if you go back to 2012 when we were going through this particular battle and conversation, I don't see any problem with just leaving everything as is.
What
Just
does it
exempt for taking.
mean?
Well, it means, the problem is that, just plain language, the problem is that a lot of times the executive and the emergency manager at that particular point in time, I believe it was, were not giving us giving our retirement benefits that
Right.
we needed, right? Like they
Right.
were not, and then it was arguments back and forth on how do we get that. The same thing that's going on right now. They just wanted something in the charter to say that something will be established. They were hoping that the argument would be done and we would be having this conversation. But in lieu of not being passed and done, we hear. And so I think the thought process was just to say, hey, the city may establish by ordinance its retirement plans consistent with law that does not exceed liability beyond the current fiscal year. The existing governing bodies for administering those plans, the benefit schedules for those plans, and the terms of accruing rights to and receiving benefits under those plans under this charter. I think that's basically like, hey, put an ordinance together that would, so we know what we're getting when we retire. because that's not happening.
Oh,
You understand what I'm saying?
No, I think I got it. So
Okay.
I think the wording is wrong because I'm glad you read it out loud like
Okay.
that. I think the word that needs to be removed for this to make sense is ordinance.
Yes.
So I think ordinance is a typo. So if you read that last part of that sentence, receiving benefits under those plans shall have status under this charter, meaning that the new charter grandfathers in whatever retirement plans are there. Now, I don't know if that's legal for us to do. I'm just saying I think that's the actual verbiage that should have been there.
Through the chair, or could say just shall remain under this charter and get rid of have ordinance status.
That's what I said. That's
Shall
because I left
remain
it
under
out.
this charter.
Yeah.
No, I get it. I'm just saying the word
Yeah.
ordinance shouldn't be there, is what I'm saying.
It should not
I
be.
do
there.
like what he noted as a suggestion. I know that my parents are going through this right now in terms of city benefits being taken away. And that was because one of our local municipalities did sue and go through a lawsuit recently, I don't know how recently, could have been over the next couple of years, that they do have abilities to change a lot of those benefits that are previously given to retirees. And so I think there is some sort of I think since this was written, there is likely some new legislation that is out there, or at least a case law that's out there that talks about previous retiree benefits. So that's the only thing that makes me a little bit nervous, is I do think there is some sort of case law that is now out there from some of what I know is going on personally.
And can I just say, it doesn't say anything about a previous.
Yeah, true. Yeah.
That one of the problems is if we have vague language, then we get mayors who capitalize on that. So I need to be able to read this and know I don't know what it's saying.
Okay. Well, again, if you take the word, I'm sorry.
Go ahead. No, I want you to.
Okay. If you take the word ordinance status out, if you take the word ordinance out and just say the city may establish, well, I'm not going to say, the first ordinance stays in.
Yeah.
Yeah.
Agreed.
I'm just saying the city may establish by ordinance, because the rationale to have this in here is that by ordinance that the city, council and the mayor will come up with a ordinance to make sure its retirement plans are consistent with law that does not exceed liability beyond the current fiscal year. The existing governing bodies for administering those plans, the benefit schedules for those plans, and the terms for accruing rights to and receiving benefits under those plans
Shall remain under this charter.
shall remain under this charter. Because, again, if somebody does come back to say, we want to change something, this charter protects current plans, or there'll be an ordinance in place that no one can change what that plan may be or what those benefits may be that's given to retirees. There's no protection for retirees.
I
right now.
get that. Why
Okay.
you slow talking me? I get that, but I'm just saying.
I'm not slow talking you. I'm just so I can explain it.
talking the situation.
No, I'm just so I can, so I don't listen. I'm personally affected by it. So I'm hearing it, and you're asking me what the background is.
No,
so
not
I'm
the background. I'm saying that we have all been over there while people have used the vagueness of the charter to do what they want to do. So I'm saying, y'all kept saying the previous, it don't say previous in here. We know the situation. I need somebody who might not know the situation when they read this to understand what it's trying to do.
And that's why I just said, just make it simple. That's take ordinance status out and just say the city may establish by ordinance. That's all we're asking.
Yeah, and I think noting the previous, I think just for everybody, I think that's what it means by the existing governing bodies, right? So we're talking about whatever, I don't remember the name, but they come to council quite often and give those.
GERS?
The GERS, yeah. So GERS would be the governing body that currently operates.
They switched over to a new name.
Right, right.
it's not.
So I think
probably
that's what
MERS
it's-
next year. And then,
Exactly.
you know,
So that's what it's referring to, is that it's that governing body, right, that is currently about government employees, and that will remain. So I think that's what so I just.
No, I'm with y'all, but what I'm saying is, during the explanation, we're using words that are not in here. So I'm saying, do those
Yeah,
words need to be
sure.
in here, or are we okay with how it currently is? I guess that's what I'm saying.
Yeah,
I'm
good
okay how
question.
it currently is.
Okay.
I
Yeah.
don't need because you can't grandfather something that's not even had a right to have in an ordinance, or you can't grandfather something in a charter that they haven't had before. They're just asking develop order.
Right. Okay, I get that. I'm just making sure, right? Because I just needed to know. Go ahead, Killian.
And it's primarily what the conclusion came to, me talking to a couple of the other commissioners. And I remember my mom, really, this was one of her stickler points before she passed. It was that they didn't have any support legally from the charter, and that the ordinance, and they wanted an ordinance with the charter backing to say this would be taken care of and taken care of properly, with the backing of your Constitution, which is our charter. So that's what, I'm being vague about it, but she was like, we need something to say that, from that the charter institute the foundation of these ordinances. Because what is gonna happen in years from now, they're gonna do exactly what's going on today. Switch names, switch things, and switch things, because of, like you said, the whole point was they took advantage of the vagueness. So they were trying to say, let's take the vagueness out, stick it to the charter.
Right.
Which we can't totally put it in there. But we can tell the charter, say, put it in the charter that you must or somehow have to have this ordinance to help retirement.
Okay, so one more thing. It also says it may establish, so it's not a guarantee that it has to.
Yeah, I see that.
No, so that's two different things.
The city
So-
may establish by ordinance its retirement plan. I'm just saying.
No, hold on, you gotta read the whole thing. The city may establish by ordinance its retirement plans consistent with law that does not extend liabilities beyond the current fiscal year. The problem with the retirement plans, which were currently stated, the good thing is Pontiac's was overfunded, but previous and other retirement plans like the VEBA and other things were underfunded. So this mandates that if the city makes a retirement plan, it has to be covered in the current fiscal year. You can't assume any other retirement debt. So we couldn't say right now, we're gonna hire another 75 employees and put them in a retirement system for the city of Pontiac that doesn't have current funding in order to do that. That's what that statement says, not saying, so it's two separate clauses. Is the city may establish a new retirement plan if they want to by ordinance.
But can I stop you? Y'all keep adding words. It doesn't say new in here. I need you to explain it to me as the words are, because those words are important.
Okay, but, Madam Chair, I hear what you're saying, but in the content in which this particular part was developed for future conversation. So when it says the city may establish is new. Because it's not saying I'm establishing something that's, or holding something old. There was nothing done. Like, just understand, like, clearly back that time having this argument, if you could just bear with me for a second.
I'm listening.
It was just nothing done. We wanted something established in the charter so that an ordinance would be done.
So this is future.
Right.
This could
So-
happen.
Correct. And the other side of the argument wanted, which was the executive side, wanted the fact that you don't make it past the fiscal year. Like, you have to do it within that fiscal year. Like, it has to be, all of what you want, it has to be amenable to what we have in that current fiscal year.
No, I get that. I am focused on specific words, because as I'm reading this, knowing the history, I don't want this to be used for bad, and we're the ones who created the vagueness.
What I'm saying is not, what I'm telling, being a part of it, what I'm telling you is,
It's not vague.
it is not vague.
Okay, I'm good then. I'm good.
And we don't need to add no new words.
Okay,
Just take out that ordinance status.
I'm good. The ordinance. So we're gonna remove ordinance out the last sentence.
I have the language. You want me to read it again?
Read it for me.
Okay. So I motion to change this section to read
What section?
I'm sorry. I motion to change 6.107 retirement plans. I'm going to take continued out. So I'm going to say retirement plans. The city may establish by ordinance its retirement plans consistent with law that does not extend liability beyond the current fiscal year, period. The existing governing bodies for administering those plans, the benefit schedules for those plans, and the terms for accruing rights to and receiving benefits shall remain under this charter. Period.
All right.
With a T.
Is there a second? It's been moved by Stewart and supported by Killian. We had discussion. We done. Roll call. I'm about to go off.
Commissioner Williams? Yes. Ibarra?
Yes.
Burrows? Yes. Garrett?
Yes.
Killian?
Yes.
Yes.
Stewart?
Yes.
7 yeas.
Next section, 6.302, emergency rules. The Attorney General wasn't really sure what was being referred to as an emergency defined by state law, which would authorize the mayor or council to adopt an emergency rule. And wasn't sure if there was something in mind. He didn't know what that would be.
My assumption is that when they probably this was definitely a section not written by us. So my assumption is that they're probably thinking about like a state of emergency that's declared by the state. But I don't know. Is that worth it to fix? It's not defined in state law. That's the problem.
Right. That's
Yeah.
what he's like, what are you talking about?
Yeah. So that's because I remember this on another piece that we had earlier too, before the attorney. So I would either say two things, right? Is one, we just take it out and nix it, and then the other would be to say in the declaration of a state of emergency of some sort, right? Like whatever the kind of process is that the state requires a state of emergency, declares a state of emergency for an area, just like,
That's a little tighter.
yeah, that might be better.
Mr. Stewart.
Is there suggestions or suggestions? Yep, sorry. Go Kermit.
I think what we should probably require is a sentence that says that the city council must adopt an emergency plan for the city of Pontiac with emergency rule ordinance. So that way, they had the flexibility to change that as state law changes it. And the city may also require something extra than what the state is. The state may say it's an emergency when it's a blizzard or something, but the city may require if it's 4 inches of snow, that is an emergency. And you need to move your cars or whatever it is. Does that make sense?
Through the chair, it does to me, but you're going to have to say it again.
Yeah. Go ahead. Sorry.
Turn your mic on. That's okay.
Because we already have established ordinances of what to do in a state of emergency, and in your, I don't see, there's nothing in here that, I don't see a need for this emergency rules, like, period. Like the wording, this 2.302, because it's not referencing, it's already ordinances establishes, but it's not even, read it over again, because I don't see it.
So, no,
That's all I
it's
wanna
not
say.
about reading it over. I just want to
Okay.
go back to some history.
Yeah, okay,
We
help me
had
out, 'cause
a person that was in the executive office
Mm-hmm.
that was trying to use the state of emergency on an issue to continue to spend money that was not there because they were declaring an emergency.
So
Oh, wait, can you say that again?
Help me, Jesus.
you right. So, okay, plain language. I'm sorry, plain language. So, previous mayor before this mayor was, we have an emergency in safety and security, and so we need to buy trucks, or we need to throw parties, or we need to.
I'll give you a real example. These chairs, these lights, all of these were ordered under emergency without city council approval of the studio, because they said we had to come out of COVID, so they had to get the council chambers up to snuff because it was an emergency. Real life example.
Yes,
of
that's
what was
perfect.
there
Perfect
by
example.
emergency. Yes.
Okay. So, and what was your language again, Commissioner Williams?
Oh, I was just saying that.
No, you got to say it again.
No, I'm trying to get the language. I don't have the language. That's why I was.
Well, we just heard you say something. Didn't we? Did you write it down?
I didn't write the full thing down, but I
But
did
you
know that
heard
it
it,
said the
didn't you?
city council.
I heard something.
Okay,
But
okay.
it sounds like,
I ain't great.
it sounds like maybe you don't even need the emergency rules. You have administrative rules, and it sounds like, based on the history, you might want to get rid of the provision for emergency rules.
No, what I'm saying, Mr. Chris, is we need to give the council the authority to make an ordinance that speaks to that in the future. I'm just saying we don't necessarily need to put it in the charter. I think that section does need to exist, but I think that by ordinance, the council can spell it out in a much better way than what we would have in a section in the charter. And so I think that not to exceed 60 days is in here for a reason. And so I'm just trying to figure out how we put the language together that makes that viable. And I don't know.
All right. Well, that was interesting. So we need to get some language.
Madam Chair, well, it's
table.
kind of difficult to come up with a language. I'm sorry.
Go ahead.
I think, through the chair to Commissioner Williams, I think it'd be difficult to come up with a specific language. I think the part where you say council needs to establish an ordinance that covers all emergency rules, period. Like, I think that is the language.
Okay, yeah, I can go with that.
Like, that is the language.
Yeah,
That council needs to establish council needs to establish by ordinance
I
that
have it.
covers all emergency rules yeah.
So I have the city council shall adopt an ordinance that outlines procedures for emergency rules.
Period.
I move that.
Is there a second?
Second by Garrett.
It's been moved by Williams and supported by Garrett for 6.302, emergency ruling to read as.
The city council shall adopt an ordinance that outlines procedures for emergency rules.
It's been moved by Williams and supported by Garrett. Discussion. Roll call.
Commissioner Williams,
Yes.
Ibarra,
Yes.
Burrows, Garrett. Yes. Killian,
Abstain.
Ramsey,
Yes.
Stewart.
Yes.
6 yeas, 1 abstain.
You staining? You staining? Go right ahead, sir.
The next section, 6.402, the Attorney General just made a comment about the percentages with respect to a certificate showing number of registered electors. He thought that the floor made sense, but his comments were that having a maximum didn't really seem to make sense and just made more work for this clerk's office, really, in trying to determine if it fell within that minimum and maximum number, and suggest why not just have the floor? Why have a target that you have to fit within.
I think
Okay.
that was the language that was there.
Right, so I make a motion that we change section 6.402 to read as follows. Duty of the council and petitions. If such certificate shows that the number of registered electorates signing is, so striking the word the, is not less than 10% of the electors voting at the preceding presidential election, the council shall within 20 days thereafter either. And continue.
Yes. Yep.
It's been moved. It's been moved by Williams and supported by Stewart. Discussion. Roll call.
Commissioner Ibarra,
Yes.
Burrows, Garrett,
Yes.
Killian,
Yes.
Ramsey,
Yes.
Stewart,
Yes.
Williams.
Yes.
7 yeas.
6.403, section on referendum at the very bottom, right before you turn the page, there's the word city should be in there. It was not included, so the proposed change is to add city.
It's been moved by Williams and supported by Burrows. Discussion. Roll call.
Commissioner Burrows, Garrett,
Yes.
Killian,
Yes.
Ramsey,
Yes.
Stewart,
Yes.
Williams,
Yes.
Ibarra.
Yes.
Next three changes are on page 32. 6.406, there's a extra word on the third line, public. The word in should be deleted, and it should read to the public each week for 2 successive weeks. 6.408 and 6.409, they skipped 6.407, so those should just be renumbered. So state law to apply should be 6.407. Effective vote should be 6.408.
Support.
It's been moved by Williams and supported by Stewart. Discussion. Roll call.
Commissioner Garrett,
Yes.
Killian,
Yes.
Ramsey,
Yes.
Stewart,
Yes.
Williams,
Yes.
Ibarra, Burrows. 6 yeas.
Page 34, 6.513, third line down, the word "and" should be an A, so it should read, sell or transfer a city utility.
Support.
Moved by Williams, supported by Stewart. Discussion. Roll call.
Commissioner Killian,
Yes.
Payne, I'm sorry, Ramsey,
Yes.
Stewart,
Yes.
Williams,
Yes.
Ibarra, Burrows, Garrett. 6 yeas.
Top of the next page, 6.701, severability, the sixth word of should be or.
And support.
It's been moved by Williams and supported by Stewart. Discussion. Roll call.
Commissioner Ramsey,
Payne. Just kidding.
Ramsey,
Yes.
Stewart,
Yes.
Williams, Ibarra, Burrows, Garrett,
Yes.
Killian. 6 yeas.
6.802, establishment and purpose, subpart D. The Attorney General didn't understand why, if the boards are being deleted out of the charter, why the boards appear to be remaining. He suggested that they not provided, all boards and commissions not provided for in this charter are dissolved. He wasn't sure what the intent was there.
I think I do think there is, we don't have like a provision outlined for like planning commission, for example, so I do get worried about like the broad language that for some reason that might be. Now that's governed by law anyway, so.
Well, I mean, the alternative might be just to be silent and not have the sub D.
Yeah, we could take that out.
Okay, I make a motion that we just strike all of section D.
Section D?
D is in dog.
Yeah, because I think at the end of the day, support, but at the end of the day, I think they can make an ordinance and just make sure that it's there, right? So,
It's been moved by Williams and supported by Stewart. Any further discussion? Roll call.
Commissioner Ramsey,
Yes.
Stewart,
yes.
Williams,
Yes.
Ibarra,
Abstain.
Burrows, Garrett,
Yes.
Killian,
Yes.
6 yeas, 1 abstain.
Next, 6.805, powers and responsibilities, sub C. The last line says, currently, the council reserves the right to dissolve or modify the powers and responsibilities of any board or commission as provided by establishing ordinance. The suggestion was to just simplify that, so the council reserves the right to dissolve or modify the powers. Well, I think it should be the powers and responsibilities of any board or commission subject to this charter. So it could not dissolve something that's provided for in the charter.
Move.
It's been moved by Stewart and supported by Williams. Further discussion? Turn your mic on.
Ordinances,
We striking that out.
yeah.
I can reread it.
Okay, thank you.
I'll reread it. It says 6.805C, the city council reserves the right to resolve or modify the powers and responsibilities of any board or commission subject to this charter.
All right. Any further discussion with people who mics work? Roll call.
Commissioner Stewart,
Yes.
Williams,
Yes.
Ibarra,
Yes.
Burrows, Garrett,
Yes.
Killian, Ramsey,
Yes.
6 yeas.
6.808, the Attorney General thought it was, the detail with respect to the appointment for the Youth Commission seemed very cumbersome. And he's like, why not have that in the ordinance? And so he proposed that it be simplified as presented, so that it would just end after the first sentence, which would read, the council may establish a youth commission by ordinance for individuals between 13 to 18 years old at time of appointment.
I agree with this. I agree with this. I think that I was also feeling the same way. I wasn't here for that meeting, so I couldn't say this when I was. But I think I'd rather have that laid out in an ordinance than the charter itself. Support.
Moved by Garrett, supported by Stewart. Discussion. Roll call.
Did you? You had something? Oh, Commissioner Williams,
You had something to say?
No.
Commissioner Williams,
No.
Commissioner Williams? Oh, no. Ibarra,
heard you say no in a while.
That's what it is. That's what it was.
Ibarra,
Keep going.
Yes.
Garrett,
Yes.
Killian, Ramsey,
Yes.
Stewart.
Yes.
5 yeas, 1 nay.
The next section, 6.809, the Assistant Attorney General just made a comment that it seemed, passing it to having the language for the Charter Review Board to be created initially, right off the bat, in the charter, he thought seemed like it may make it more difficult to suggest to the population to support the charter. But
Yeah.
I don't think he pushed back on it, but
It's not clear. Yeah, the reason why we added that was because our timeline was shortened. And so we said we know that we probably missed some things that we would really like to eventually have folks look at immediately. And so we thought it was easier to kind of have that worked in, as well as, right, we haven't had a charter update since I think we had like a couple small ones, but the ability to have that on a consistent basis and making sure that that's a regular occurring piece is also something I thought we were important because.
No, I'm not,
yeah,
I'm
just noting.
Again, I'm the messenger on that. I mean, it makes sense, whether or not to have it in the charter versus a committee that council could always appoint. But the point is, if you want it to stay, that's fine.
I motion to keep this provision in the charter.
So it's been moved by Stewart and supported by Williams to keep this provision. Is there any further discussion?
I'm scared to talk.
Say it.
Say it with your chest.
When Madam Chair gets like this.
Oh, my God. Okay.
No, I'm good. No, ma'am. I'm good.
Roll call. What you say?
I said, give her a snicker.
Roll call.
Commissioner Williams,
Yes.
Ibarra,
Yes.
Burrows, Garrett, Killian,
You okay? Can we get him some water?
Roll call.
Hold your hands up while you're walking, too. Choke.
Get some water from the water fountain, y'all.
Get some water. That's what he's trying
Thank you.
Commissioner Ramsey,
Yes.
Stewart.
Yes.
6 yeas.
The next section,
Y'all funny.
7.101, which is the ethics and public integrity section. On page 39, he proposed and made reference several times to the state statute regarding conflict of interest and contracts, and so he wants that included in. He wants it on page 39, page 40, and page, I guess we can go one at a time. Page 39.
No, we can do it all together.
Page 40, there's a couple of other proposed edits that he had regarding sub 7.102D regarding campaign contributions and expenditures to clarify regarding city proposals for city elections. He didn't think it made sense regarding some national matter. And then 7.105, again, he made reference to the MCL 15.328 section.
Okay, I make a motion that we change all three.
Support.
It's been moved by Williams and supported by Stewart to including MCL 15.328 where appropriate. Discussion.
And section D on 7.102, adding the language that says regarding city proposals or city elections.
All right. Any discussion? Roll call. I said that one. Yes.
We almost do.
All right, Commissioner Ibarra,
Yes.
Burrows.
Yes.
Garrett. Yes. Killian.
Yes.
Ramsey.
Yes.
Yes.
Williams.
Yes.
7 yeas.
Hello.
The next section is 7.106. He proposed the deletion of that last sentence. I'm looking at it. I mean, I think he would get over it, but I mean, it's he did point it out as he didn't think it was necessary. That's really a focus of some type of lobbyist or employee of a contracting party offering a prohibited gift, making the potential contract voidable.
Anybody have any feelings about this? Oh, look, Gil had to take his glasses off to read that one. We serious. We serious. Ibarra.
Just for point of clarity, so the very last couple of sentences, if that's even one sentence, the reason why we're moving that is because it's offering or mandating a punishment, if you will, or something has to happen because
No, I
of
just
the.
don't think the Attorney General felt that was needed. But I mean, it doesn't violate anything, right? No.
He pointed out that language, but I would not say he was strong on that point.
Understood.
Please go.
Could it be, not that I don't want to insult anyone's intelligence, but could it be, because this is, when I read it, when it says such contracts shall also be voidable or rescindable if a lobbyist or employee of the contracting party offers a prohibited gift. There were, at the time of this particular language, there were people third parties basically being used as the mediator. And after the FBI concluded its investigation to find out that it was third parties, they decided to place, I think that's what they meant by putting that language in. And so understandably so, we don't want anything like that to happen again. Sure. But it has happened. We've now entered into the marijuana space, and I would just say that I would leave it in the charter, because people know people, and they think they're smart when they use a third party. And I understand his concern. But people often use other people to have a conversation for them. So there's another way that the Attorney General can.
Well, no, he did not specify how he would.
Okay.
He didn't wordsmith that section. I think maybe he also, the third line up from in relations to the contract, I think he thought that was awkward. But whether he was.
You say where do you put it at?
Where it's what is currently struck through. Such contracts shall also be voidable or rescindable if a lobbyist or an employee of a contracting party offers a prohibited gift, gratuity, honorarium, or payment to a public service in relations to the contract. I'm not sure what that means, really.
Well, I don't think you necessarily need that in relations to the contract anymore, because it speaks, if you just make it as plain as possible that no third parties can be involved in any part of offering gifts of these types or lobbying on behalf of a contracting party. I think that's pretty much what they were trying to get at when this section was specifically written. But if that, I don't see why that needs, to your point, you can strike that out.
Williams.
Yeah, I think
Because
that,
it says,
to Jose's point, the shall in the last sentence, meaning refer to the appropriate prosecuting authorities. I think that the question then arises, if somebody's doing business with the city and they offer to marry some golf clubs, does that mean that they should be referred to the proper prosecuting authorities? You get what I'm saying? So
Yeah.
I would
Take
I
that
would
out.
make a motion
Oh, wait, can you not, I have something to say too. I want to have some conversation before, because I don't want to have to undo it and do it again. I'm sorry, Madam Clerk over there. So I guess my question is along the lines of Commissioner Williams, because then I start getting scared. So I have friends who work here, right? I also have a contract with the city, so if I bring them some Starbucks, I'm in trouble?
No, it's not saying, I don't think that this is,
For that?
that was intended for that purpose. I think at the time that this was, the thought process behind this was a little bit more in depth of, we had a lot of contracts coming up, a lot of bids going out, and then there was third parties. Matter of fact, just, you know what? So just, matter of fact, just within the last, I would just say, the previous administration, somebody had a job that was titled one job, but yet they were doing another job, and possibly have accepted gifts in lieu of favors, and it had yet to be proven that the person knew that the other person was accepting gifts on their particular behalf, but yet benefited from that attempt because they were in a romantic relationship, or possibly in a romantic relationship. Allegedly.
Yes, Williams and then Burrows.
Okay, just to coincide with what Commissioner Garrett said, prime example is an entity who was a personality of the city, setting up a nonprofit, having a fundraiser before the city event in the same area in which they had the actual city event that was mandated by the charter.
Yes. Okay.
So go ahead, Mr. Stewart.
Just quick, there's also very clear provisions around gifts and gratuities and what that means. And so that's all outlined in the provisions ahead of that. So it would really mean like gifts and gratuity, honorary, like that's really what it's getting to, is like the provisions ahead of it that talk about gifts and gratuities.
So would it be?
So I got a motion.
Okay,
So,
go ahead, Williams.
Okay, so my motion would be that, starting with the stricken out language, such contracts may also be voidable if a lobbyist or employer of the contracting party offers a prohibited gift, gratuity, honorarium, or payment to a public servant, period.
Yeah.
Burrows, go right ahead.
I rescind my motion.
You better not.
The city, hold on. How about, okay. Contract, do not accept bribes. There it is. You won't have to put all this special word.
Somebody send him home.
All right, can you keep your motion?
All right. Okay, Williams made a motion and Garrett supported it.
So I'll reread my motion.
Please.
I'm supporting. Such contracts may also be voidable or rescindable if a lobbyist or employee of the contracting party offers a prohibited gift, gratuity, honorarium, or payment to a public servant, period.
It's been moved by Williams and supported by Garrett and all of us but Burrows. Roll call. Commissioner Burrows?
Yes.
Garrett?
Yes.
Killian? Rent?
Yes.
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 Ibarra?
Yes.
7 yeas. That was it.
The next section, 7.202, appointment, removal, term of office, and vacancy. That's addressing the public integrity officer who's appointed. Subpart D talks about recall. You can't recall a person who's appointed. So the Attorney General said that should be removed and it should be.
Makes sense.
Who made the motion? Garrett made
Support.
the motion.
Support.
Ibarra supported it. Roll call, no discussion. Roll call.
Commissioner Garrett. Yes. Killian.
Yes.
Yes.
Stewart. Williams.
Yes.
Ibarra.
Yes.
Burrows. 7 yeas.
The next section now, going back, and it's really the last section, 2.102, back at the beginning, talks about elections and the concept that the commission has discussed was to change the scheduling of city elections from the odd year cycle to even years. And that has, the charter can't do that, but the Michigan election law, and you have a copy of the section, does allow for that to be done. There's a specific process associated with that. All of the items in the section of 168 MCL, that's section MCL 168.642 of the Michigan election law, you should all have a copy of that, can be done the way, if this commission wishes to mandate in the charter that the council at some point subsequent to the approval of this charter, the process would be for the charter to direct council to pass a resolution consistent with this Michigan election law, MCL 168.642, and then also 168.642A, which I don't have attached. I didn't print that out.
Go ahead. I just wanted to note for the commission that this was a change that the previous charter commission had wanted to make, and so I just wanted to note the current provision that's in our current charter. It reads, regular city primary and general elections shall be held on Tuesday following the second Monday in September and Tuesday following the first Monday in November of odd years. City elections are nonpartisan. So what the proposed change is regular city primary and general elections shall be held on the same date as regular state gubernatorial primary and general elections. City elections shall occur in accordance with state and federal law. They're nonpartisan. So that's
changing the cycle
exactly.
from odd years to even years.
Exactly. I think that was like the reason I note that is that I don't think we intended that. Like, we just didn't read, like, we approved the 2012 charter as it was, but we didn't necessarily note that that was in there. We did, but
We did because we wanted a bigger turnout for election. The problem with that is this charter takes place July of next year, if it passes, which it hopefully will. And then the people who run in that election, if they already had filed or whatever, would then have to run again in 2026 under how that charter states.
I think Vice Chairman Williams is accurate. One of the concerns, and I did briefly discuss this with him, is the concern with respect to those candidates, and does it confuse the citizens if the charter has this direction and then council takes the action that the charter directs, that they pass the resolution. There's at the very bottom of the statute, it says what has to happen. The council has to, before adopting the resolution, the council has to hold one public hearing on the resolution. The public hearing may be held on the same day and immediately before considering the adoption on the resolution. Council has to give notice of each public hearing on the resolution in a manner designed to reach the largest number the jurisdiction's qualified electors in a timely fashion. The council votes on the resolution, and on a recorded roll call vote, a majority of the council's board members elected or appointed and serving adopt the resolution, and then the council files the resolution with the Secretary of State. The other section, which you don't have in front of you, which is, again, MCL 168.642, small a, sub 4, has the provision that says if this happened, the change of, so if the council, if the voters approve the charter, if it takes effect in July 1 of 2025 as currently proposed, the council then passes the resolution sometime thereafter. The change in the election to even years does not happen until the following calendar year. So the elections for 2025 would still happen. Then the change would happen for all subsequent elections. So it would actually be, instead of 2029, it would go, they would get an extra year. So it would go then to the even year. So it would be 2030, 4 years. They would switch it to 4-year cycle. So it's just a timing issue that I think it's important for the commission to understand how that works, and not only how it works, but when it may wish the effective date of the charter that it proposes to take place. So, Vice Chair Williams, that's slightly different than what we had talked about earlier today as far as the timing.
Right. So I would make a motion that the charter would be effective January 1st of 2026. So that way, whoever got elected in 2025 would then not have to run again until 2030. Yeah, because you can't give people less years. You can only give them more.
And in the proposed
Or we
text,
could just keep it on odd years and not worry about it.
you do have proposed text in 2.102 that would say that, it would say that every part of it except for when the effective date of the charter is.
Yep.
No, what I'm saying, yeah, the charter would be effective 2025, because there would be no need for that additional change in provision. The problem we have now is by switching it to even years, because we got an election next year, those people would either get they would get 5 years or they would get 1 year, and we can't make it 1 year because that's lessening the term of their
Let me
office.
slightly modify that. It really, if you had it effective next July 1 and council takes the resolution, it still doesn't go effective until the following December. So those people who are seeking election next fall would still, you would still have that fall election. They would just go until 2030. So, I mean, it's really, well, the election.
It'll change the elections going forward, so it'll be 2030 and then it'll be 2034.
Yes.
If we leave it now, it'll be 2029 and 2033 and whatever. It would never go to the even year cycle.
And this is proposed to get because of voter turnout.
I mean, that was one of
Well,
our
I was-
reasons for
yeah,
thinking.
thinking.
And then also to cut down on the city money. If the city doesn't have to do a mayoral election, that's a savings in actuality, because you're all putting it on one election that's gonna happen anyway. So, but I mean, I'm neutral.
I mean, it
either
seems
way.
like it sounds neutral the way that y'all just explained it. Like, to be honest with you, like either you 2020 is not either way. It's not going to take effect until 2026. Is that what I'm saying?
No. What we're saying is, if we change the years to even, the people who get elected in November of 2025 will serve until 2030, so they would end up with an extra year. So the question is, do we want to switch it to an odd year, and by virtue of switching it to an odd year, give them an extra year, or an even year, give them an extra year, or do we want to keep the current system that we have, which is odd years, and so they would only get 4?
I say 5 so I can run and be in office for 5 years.
So I'm voting for Tamika, so we're going with 5 years.
I'm with you. Let's go. I'm with you, yeah, that part.
So, but
I'd rather be in office for 5 years.
yeah, so.
No?
And I want to just noting, I know we gave the reason we said July 1st was just because it's a new fiscal year, right? So that was kind of our thought, was like, it's easier to kind of implement those changes. Is there anything
No,
we should consider around that timeframe? Nothing?
No, thinking it through, if you're still comfortable with making that change, it works. I wanted the commission to realize that it doesn't, even if the
Implement for a
council
while.
then has the meeting July 10th and gets,
Yeah.
it's not going to change the election that's scheduled in November of
November
25.
Just give them an extra, just give them an extra.
That election will still continue, and then the following cycle is when the change would happen.
Okay.
Okay.
So what do y'all want to do?
I want to give them an extra year.
And Ibarra. Oh, go ahead, Killian, and then Ibarra.
Part of the reason we were moving this was,
Turn your mic on, sir. Turn your mic on.
part of the reason I think some of us was moving this was financially. It was a financial advantage for the city to hold an election, and we thought we would get more people during this cycle. With that said, how much financially will it save the city to add a year to someone's running and to switch this over? Does it make sense to actually do that from that point on?
Okay, I think we lost the chair, so Garrett, yeah.
Well, I think it makes a great deal of sense. We recently, over on the district side, moved to 6-year terms. It's not so that you wouldn't have to keep going through elections, you know. In just all fairness, giving someone an extra year in this particular city, we don't recall anybody. So I don't, you know, if it's in time and how things are done or have been done, I wouldn't mind. I prefer to make the switch now and they go to the even years because, I mean, what was it, a couple thousand adds up over time. You know what I mean? Like, it just add up. I'm not saying it's not going to cure the structural deficit without a vision, but it does add up.
And let's be clear, like, running an election is like tens of thousands, right? Like, like, it's huge money, right? So having to do that in that year actually does save, if it's not just about the 5-year term, right? But it's about every subsequent election after that we're saving, tens of thousands, so, yeah.
Do we have a roundabout figure?
Okay, all right. Commissioner Ibarra has not spoken.
I would just like
Over $50,000 is the note to run an election.
To run an election, right.
Yeah.
point of clarity. So if we were to move over to the even years and the charter go into effect in 2026, does this affect positions for the people who are running for? I know we added a full-time council president as well as an at-large council member. Would those not take effect until the election year of 2030?
I get what you're saying. What the question would be, when do we make the charter effective? And so that's what we're asking Mr. Chris, is when do we need to make it effective? But it does answer your question. When would the charter actually take effect? I'm saying there's no difference between July and January, because if it started on January 2026, it would take effect because that's when the new people would take office anyway. And so if we started it before then, without having an election, then how would they even do the at-large or whatever? So
We had put in the transitional provisions that they would keep their current 4-year term. So even if it went into effect in July, they'd still have until the upcoming election in 2025.
Right.
So that is good, but that is a good question. In that 2025 election, then, if regardless of the move to the even years in that 2025 election, those provisions that we added in around at-large and districts down to 6, would that take effect, correct? That is, yeah, too.
I think it would. And that might be a reason to push it to, because you don't have that, the creation of that district.
Yeah. I think it depends on when they have to file for office too, right? So how long does, that's what, I think the goal is that we would want to probably have those provisions take effect sooner, right? We're fine with the extra year, but I do want the at-large and the city council president to take effect. So if it would make sense to move that effective date, maybe there's the effective date, whatever that is. I don't want that to be lost to another election year.
Well, then, I mean, I think if that's the case, then we need to move the effective date of the charter to when the charter passes.
But I don't think we can do that because they need time to process the changes.
That election, switching it to even year, it will still be the next year. It's the year after the resolution is adopted by council.
Right.
So what I'm hearing is that we can make the start of the charter at the 2025 election year, but then also put in there that you're going to gain an extra year because the terms are going to be switching to the even years.
I believe I'm hearing the same.
That's what I heard.
What I'm saying is, and I hear what both of y'all are saying, I'm saying that in order to create the new district, which would be, well, create the new districts, because they would be shrinking, well, it's good moving to 6 instead of 7, we need to make the charter effective before then, and then the elections for the new term would then start in 2026, would be an even year. So you get what I'm saying? So the part of the charter that establishes the districts need to be effective before 2025. So the people who are running in 2025 will be running in the new districts.
Yeah, but when do they file to run?
Yeah,
That's, I think, the most critical piece, right?
Yeah, they file in like January or whatever. What I'm saying to you is we have an election in August.
For 2020, so for the November, is it August 2025 election that they normally are?
So they have their primary in August and then a general election in November. What I'm saying to you is the filing deadline is usually April or May for August. What I'm saying is if the people pass the charter this August,
yes,
we could make the charter effective starting in January 1st of next year. Anybody who would run under those new districts because the people would have had to have those ordinances in place.
yes, but I also wanted to give, go ahead, Attorney Christ.
well, that's if it stays in a 2025 election cycle, though, right? Mm-hmm. I thought you still wanted to change it to an even year.
No, I get that, but what I'm hearing is the other provisions of the charter, which were created by the districts, wouldn't start for 5 years, which defeats the kind of purpose of making the new charter.
That's what I said. Yeah.
So what I'm saying, so I'm changing my stance and saying
That's what I wanted him to say out loud.
We may need to.
My mama called me. I got to go.
Hold on. No, I don't.
Yeah, let's hold on.
I don't even know. What I'm saying is, in order for the district part of the charter to take effect, we have to keep the odd year elections in order for that to be feasible in the foreseeable future. So even though I believe that we should be moving toward even years, I don't think we can wait 5 years for the updates of the charter to take effect in the governing structure.
And I think subsequently then we would need to move the date up of the effectiveness of the charter so that these new districts and at large would need to take effect earlier. Now, I don't think January is possible, quite frankly, but before it was noted as an April 1st start date. We moved that back to July. In the previous charter, it was April 1st or something like that. We moved it that back to July. The reason is that you need to have those new districts allocated as part of the charter to file and run, right?
No, I agree, Scott, but what I'm saying to you is if the charter passes, the new charter could be effective immediately because we have the transitional provisions in the charter. So
My worry is on the rest of the provisions, right? Which are like, you immediately gotta, there's a lot of structural stuff that both the city and the council has to figure out. That's not just, like, the public integrity officer then has to go immediately on to August. You know what I mean? Like, I think there's just a lot of stuff to figure out. The transitional provision, okay, I'm not making stuff like this because I'm getting a lot of stares, but the transitional provisions.
Well, stop staring.
No,
We're
because
listening.
it's not. No, Scott. Listen, it's not. Don't misunderstand the looks. It's trying to understand the years. Because what he's saying, what I agree, I would prefer it to go to the even years because we need the numbers, right? Like, people just don't get out and vote unless it's a presidential, make it plain, it's a presidential campaign, and, they get out and vote more. We're going to save $100,000 over time, maybe 2 cycles, maybe $100,000, okay? However, if we don't put these early provisions in, we wait in 5 years. To your point, there's other provisions in the charter. The people that we have to elect, they just gonna have to be smart enough to work it out. I'm about to say this, Lord, forgive me.
Don't say it.
You're right. You're right. Thank you.
You got to be
You right.
spoken like that.
You absolutely right. What I am gonna say is I do agree with Kermit by doing it. But we can't be afraid that the people who are going to get elected is not going to be able to, you know what I'm saying? You put some other teeth in there.
My thought was,
That's
the
what it
reason why
sounds
we wanted to give them more time is because there's a lot of stuff to figure out to do it right? So
Yeah,
I don't
but
want
they
to say
don't have to
January.
figure it out.
But they do, right? Because not all of these provisions are subject to transitional provisions, right?
Right.
There are certain things that have to go into place when we say that the charter needs to be effective January 1st, and I don't want to rush that just because we need to move that charter up. That's what I'm saying. So I'm saying there's clearly a need, even if we move to odd elections. Kermit's suggestion was let's move that to January 1st, 2025, and his second suggestion. I don't think we should move it to January. I think we should do it. We need to implement this charter before the filing deadline so that the districts are changed and the at-large are changed. But I
that's
would rather give
January.
them a little bit more time and say something like an April 1st as a starting point. So then they have at least 2 quarters, right, to figure out how do we implement an Office of Public Integrity? How do we implement some of these other critical things? Because you're thinking you have August to December to implement all of these provisions to be actually in tune with what the charter is saying, right? I don't want to rush that timeline because that leads into sloppiness. That's what I'm saying.
No, but
It's more than just the
you
election
don't,
process.
after we pass this charter, it's going to be up to the elected officials who you have that we elected to make sure that that's implemented. That's not on us.
But they also don't know that if this is going to be implemented or not until they get a vote of the voters in August.
Okay, but even then, it is the responsibility of the people who are running to make themselves aware of this process. We know people have not, and we know people are just going to count on people giving them different informations or whatever interpretations they may have of it. Unfortunately, that's where you and I live. However, we cannot.
Is to change the date to April. That's all.
But you saying January to April, you still not giving them enough time.
Well, it's better than January. Go ahead,
I just had a question for Mr. Chris. Is there a way to start the electoral provisions of the charter without the rest of the implementation of the charter?
No, because it's in the current charter.
You said what? Say that again?
Because it's subject to the current charter.
No, I get that. What I'm saying to you is, okay.
So you got to change it. I mean,
So you're asking to keep the current charter in places and then adopt the new charter in places?
No, what I was just saying is there are certain date mandates by the electoral calendar that are not necessarily subject to the regular governing law. I'm just saying that the implementation of part of it is their ability to say, okay, this is for the election period, the rest of the charter is implemented 6 months later or whatever. I just need to know from the lawyer if that was something that could legally be done.
I'm not aware of that bifurcated effective date, where it's bifurcated, where there's multiple effective provisions. I'm not aware of any that have had that.
Okay.
So let me ask this question then to Scott. If you move it to April, and we say we're moving it to April 2025, right? Versus January 2025. And they still have to file in April 2025. What am I doing between January and April that's different than what they will be doing now?
I am talking about purely implementation of the existing. So thinking about the transitional provisions, effect on existing city legislation, the city attorneys shall, as soon as practicable, recommend to the council such changes as may be necessary to make provisions of existing ordinances consistent with this charter. So they have to go through a process, right? It's not just about the election, right? I'm thinking about
Okay, that's
all
fine.
the
Let's
other
go
things,
past
right?
that.
So we're
The
past that,
attorneys,
right? Okay,
the attorneys
good.
have to go through the attorneys have to
They
present
gotta go
something to
through all this
council.
stuff.
The attorneys do.
If we give them a 3-month process to do that, and yes, I do realize that they could get started, but I personally, at my job, wouldn't want to do starting 7 million hours of work when I don't even know if this is going to pass or not. I'm saying if you give them from August until January to recommend all of the changes to be consistent with this charter, if it's effective in 3 months past the date, I think that's a rushed timeline, and I would prefer they have a little bit more time to work out the provisions that are necessary, right? Because think about council process, right? You got to have a first reading of a change of an ordinance. You got to have a second reading. Like, we are telling them to do that all within a 3-month time frame to be consistent with the charter updates.
Okay,
That's all.
but I just
Jose has the floor.
I do believe when we were reviewing the council or the district revisions, I do believe that there was something that said that rezoning the districts takes at least a 6-month process, I believe. So I think that's where Commissioner Stewart's concerns is coming from, is we can't say that the charter has to be established in January if there's different timelines that require more time of at least 6 months.
That's what I'm saying. That's what I'm saying. So tell me what the difference is between if you say that if the charter, if they vote on it in August, this August, 2024, and it goes in effect in April of 2025, is there I can yield. I don't have you know what I'm saying? Like, is it anything that else in the charter that will prevent you from saying or just going to April or January? Like,
I'll note no one really gave two craps to whatever day the reason was that we chose July 1st.
okay.
But we knew that there would be things that might be impacted. We just didn't have an opinion on it either way.
Okay.
Now we're seeing that there may be impacts, right? About our elections and stuff like that. So I think that's just the reason. So it's currently a July 1st start, right? Clearly that won't work based
July
on the
1st,
elections.
2025.
Correct. so that we gave them more time. But
Okay,
the original
right.
charter in 2012 asked that it be implemented by like April 1st. So all I'm saying is, let's go back to that original language. It just gives for a little bit more time, and that's all.
Which would keep us at
Which would keep us at the, yep,
the 2025 deadline.
correct. Yep,
Instead of July.
yeah. That's all. I think we were just talking in two different
Okay.
worlds,
Perspective.
that's all.
Okay.
So I think it makes more sense now. Thank you, Jose, for
Yeah.
getting us on.
Because I wasn't,
No, I
I don't expect,
feel you.
I don't expect the current administration to start something September 2024 and have something by January
Which is my
2025.
concern,
Like,
too,
no,
yeah.
I'm sorry if I ever thought that and gave you that impression that that could be possible. I apologize for that
You're
publicly.
good, you're good.
That won't
That
never
was just,
happen.
exactly.
My question to you was the timeline, because I was asking about, because we put in there that we will do the redistricting, what is the legal timeline that has to be done? Go ahead.
If I may, I do believe July was a good date where we said it was plenty of time for the districts to be rezoned, as well as either right before the fiscal year being introduced. So, I'm sorry, can you clarify?
July is the fiscal year.
July is
So it's easier to think about budgeting too. But
in which we can still give that opportunity. So what date are we finalizing?
Okay, that's what okay.
I'm trying to find the legal, because that's what's gonna count. What legally can we do? If they say 9 months, it's gonna take the redistrict, that threw his April and everything out the window. Or whatever time, so I'm asking what legal,
Yeah, I don't know the exact timeline on
and we need to know that.
on the district creation aspect. And it sounds like there's really two issues. One, it sounds like the consensus might be getting away from the even year proposal that's in front of you, now focused more on the district and the creation of, modifying the districts as a bigger priority for the commission
Right.
than the
True.
changing.
That's a correct statement.
Yep.
I agree.
So I think there is consensus, yes, to change back to the original provision around odd years. So I think
We good there.
we're good there, but we do need to approve it. So do you want me to read? I can read it in motion of the original language. So the original language states,
Scott, excuse me.
yep,
But the whole thing is still gonna come down to, and I get, all of us are consistent of the 25, but we need to know when that timeline of that redistricting in, before you can say that second part of it.
the second part would be, the second part comes into when we talk about schedule in Article 9. So that's the other piece. So I think we can approve the odd years,
Okay.
and then we can have a conversation around the schedule.
No problem.
Makes sense? Cool. Yeah, no problem. 2.102, elections. Regular city primary and general elections shall be held on Tuesday following the second Monday in September and Tuesday following the first Monday in November of odd years. City elections are nonpartisan. And I motion.
Support by Garrett.
Has been moved and supported. Any discussion? Seeing none, roll call.
Commissioner Killian,
Yes.
Ramsey, I'm sorry, she left. Stewart,
Yes.
Williams,
Yes.
Ibarra,
Yes.
Burrows,
Abstain.
Garrett.
Yes.
5 yeas, 1 abstain.
Okay, now the second piece of this. So the schedule. The reason I think we have to move to April, here's my thought. It takes, so we are giving them about 7 months, 8 months to get this done if we go by April. That is still before the filing deadline. Which is fair. The other thing is that you can maybe talk more about the redistricting process that you had to follow as a council person. Now, I will say that was every 10 years. So it's a pretty, it probably is not as consistent, but maybe you can give some context, Kermit.
So the current process that city councils usually follow, let's just speak for when we were in office, because I think we had to do it twice because I was there 12 years. So we did it when we first came in, and then we did it again. You have to be within 1% of the district. So the county does a map, and they give you 3 or 4 maps, and you choose which one is the best, right? And so I think that process can be done quite quickly with the computer mapping systems that they have. So that shouldn't be the issue of them actually drawing the maps. The issue is with coming up with a new system, the political piece of drawing the maps and having the current body have to draw maps that may not include them or may put them in odds with another council person. Could be problematic for them, but they would have to just do
Figure that
so.
out. What you all did, right? I know, street by street. That is the process that will take probably the longest, right? I think we could work with the county to get something pretty quickly. I think, is there then, just double checking, is there a process for public comment or anything like that in terms of the districting?
Yeah, I think they have to have a public hearing just like anything else.
Okay.
It's a regular ordinance.
So it can go as fast or slow as the council?
Exactly.
Okay, so I don't think there's a set dead date of 6 months, but I do think, right, that process, if you do it well and right, would take a little bit longer, right? But I think we give them the mandate of April 1st because the filing deadline comes after that. So that was my thought, I think, on it, Killian, I think is kind of following that timeline because I kind of have heard that process before. If that's comfortable, that's why I think I'm comfortable with an April timeframe.
No, I just wanted to hear
Yeah, no, I
what
think-
was the difference
I know, I
between
love it.
January, because if it's going to the people to be voted on, and it's a process,
Yes.
I wanted to make sure that
To
we gave ourselves time in this charter,
Yep.
rather than shorten it. If we
I
read
agree.
January, and then it's, no, it took 8 months, now we all out of bounds.
Right.
So that's why I was trying to,
Yeah.
that was my only questions on that.
No, I appreciate it.
I'm
So
good with April.
is everyone good with an April timeframe?
I'm good.
Let's make a motion.
Okay, I motion to
Support.
move section 9.101B to note, if this charter is adopted, this charter shall take effect on April 1st, 2025.
Okay, it was moved by Stewart, supported by Ybarra. Any discussion? Seeing none, roll call?
Commissioner Stewart,
Yes.
Williams,
Yes.
Ibarra,
Yes.
Burrows. Killian. 5 yeas. Hallelujah.
All right, so now, Mr. Chris, we need your proposed resolution to adopt the proposed charter.
Thank you, Vice Chair. I did prepare a draft resolution that would essentially indicate the commission would be adopting this proposed charter as revised. It does, if you see in the resolved paragraph, allow for editorial changes, including grammar, punctuation, and numbering to the extent that it's modified in the final product, and to allow for me to transmit another updated copy of the charter to the governor of the state of Michigan for her approval and the Office of the Attorney General in accordance with state law. It additionally resolves that a copy of the charter be filed with the city clerk, the Oakland County clerk, the mayor, and council, and that it specifies that the proposed election would be submitted to the qualified electors at the August 6, 2024 election, as well as identifying what the question would be.
I make a motion that we accept the resolution as written.
Okay.
Support.
All right, it's been moved by Stewart, supported by Ybarra. Any discussion? Seeing none, roll call?
Yes.
Williams,
Yes.
Ibarra,
Yes.
Yay.
yay, Killian. 5 yeas.
All right, thank you.
Resolution passed.
All right,
Thank you, Attorney.
thank you, Mr. Chris. Which brings us, all right, to item number 8 on the agenda. A presentation by Commissioner Ybarra and the Outreach Subcommittee team, unless you want to table that.
I don't mind.
No, it's up to you.
I don't mind. No, I'll just. I don't plan on going through the whole presentation. I just plan on reviewing and just explaining the experience that we've had so far in the outreach. If I may, Commissioner Killian, representing the subcommittee team. The outreach committee created a presentation. I believe it was around 42 slides or something like that. We also created a script that was 28 pages. Now, I actually presented that for the first time at a community district meeting, and I was able to cut it down as low as 45 minutes. Realizing after that, coming back and reviewing what could have been better. So we ended up talking after the meeting, in which was discussed. First and foremost, 45 minutes is way too long. We probably lost a lot of people's attention after the first 15, 20 minutes. There was so much information that we changed in this charter. My eagerness to put everything that we changed got the best of me, so to speak. So went back, and Commissioner Williams and I actually had a discussion where we should revise our approach from a presentation to a conversation, and more present more of a top 10 greatest hits or a top 10 amendments that were changed in the charter, and then start the conversation from there. So that can be a one-pager, no problem, introducing that. I did also want to include what's new, or before and after, if you will. So what was in the charter before and what we revised, what's new and original, and what stayed the same. I wanted to add that more of as a packet to build off of the top 10 greatest hits, but we can always do the one pager as the top 10 best things that were revised in the charter as well. So that is created. That is, the packet is being worked on, I guess. Because one of the things that the residents were concerned about was they wanted to see what was changed before and after. Now, of course, we could just say, well, look at the revised charter and see what, read the charter, if you will. But I feel like in this case, we have the opportunity to be able to translate the information that's in the charter to be able to have the residents understand what exactly have we changed. So that's why it's crucial for me to create the packet to show the before and after. Let me know if it's worth it, if I should even pursue on that, because the 42 slide presentation really crushed my soul after it wasn't successful, of course. But yeah, we changed so much. I wanted to emphasize that people realize we need some time and we need something in our hands to be able to process what was presented after the presentation. So just want to bring that up on the table as to any recommendations, questions, concerns, maybe even life affirmations.
Well, I want to say, and then I'll turn it over to Killian. I just want to say thank you, Jose, for really taking the bull by the horn and coming up. It's not only a labor of love for you, but I appreciate the hard work that went into that. So I don't want you to be discouraged by the fact that you were oversharing with the people that were there, because we're all excited about the charter, and I'm just thankful that you and the outreach team have been doing that kind of work and been able to get feedback, because it's not until we take it to the people that we know where they'll have problems or issues with actually having that. So
I'm going to second and camelback what Commissioner Williams said about the great job you did. 95% of the people that were there at the CDC meeting appreciated it. You saying the length was long, but they did appreciate the time and effort and the information they got. It just was overwhelming because it was a lot of information. The 10 greatest hit things, I think, will be a hit alongside of what were the changes from those 10. That's what we really need to get to the meat and say what we want to push. But other than that, I think it went very well. And from the people I talked to, which was the majority of them, said pretty much the same thing. They just needed time. And of course, it's Pontiac. They're not going to, some of the people are going to complain more than they're going to read. Or when they get the opportunity to hear the truth, you know, it's just sometimes, okay, well, you gave me too much. This is what you asked for. So, but however, like I said, I want to commend you on the job you did. And it was great feedback that, you know, a lot of them really appreciate it. But like I say, moving forward, we do need to cut the time down. And I think that's pretty much it, and give a visual as far as comparisons. But thank you again.
Commissioner Ybarra, we are going to move to closing comments. We'll start with Commissioner Ybarra.
Thank you all for the special meeting today. Thank you to our attorney, Dan Chris, on his work and efforts that he's presented us today, and his efforts with working with the Attorney General's office. Yes, looking forward to continuing to attending these outreach meetings. Each meeting we attend, I feel like we'll be more equipped. These are the early stages, but we're also not afraid to present during these early stages as well. Just bear with us as we're still trying to evolve as to how to educate with the community. So appreciate you all. Looking forward to the future outreach meetings that we'll be attending.
Commissioner Stewart. Commissioner Killian.
First and foremost, praise to Allah and honor to the Prophet. Thank all y'all, and I honor everyone here and everyone listening and can hear my voice. I want to give a special honor to my mother, Miss Evelyn LaDuff, and the work she put in with Pontiac and my family. I also want to say, like I said, thanks to everyone here. This was not an easy task, but I think it was well worth it. Will I do it again? Not, absolutely not. However, I did it, you know, get a lot out of this. And like I said, I really appreciate everything everybody has done and moving forward to get this passed. Still got a little work to do, but it's worth it because I do see that we have some genuine, trustful, and transparency truth coming forward to us. So regardless of the outcome, I just want to commend you. Thank you.
Commissioner Burrows.
Yeah, I want to piggyback off that. I do want to commend all the charter commissioners. I was kind of concerned when we got the charter back, but I am proud of us that it wasn't that many changes that was made. Like, so the Attorney General basically agreed with what we did. So I'm proud of all of us and putting in the time and effort that we've done. And to the city of Pontiac, we coming out for y'all. We coming. So y'all get ready. If y'all want to learn about this charter, stop complaining and start reading. Thank you.
All right, Ms. Granderson. Any closing comments? All right, well, we're gonna adjourn this meeting at 9:04. We talked about it's 9 o'clock. I offended everybody. They done left the meeting already. I need to sit down. I'm glad I worked out before I came.
I just want y'all,
We'll find out. We'll find out.
each and every one of y'all.
What y'all think?
She's like, I wanna get my.
Your meeting next week is canceled?
I don't think we need to, listen, we'll check with the chair.
Unless he